Welcome, everyone. We are pleased that you have joined us for today's webinar titled Another Crazy Beneficiary Designation Case. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice in Franklin, Tennessee. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Lineberg, and Linus regularly speaks at industry events. His latest book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, is now available on Amazon.com. Linus will draw on his legal, tax, and life insurance background and his practical experience for today's webinar. And here he is.
Thank you, Jennifer, and welcome everyone to today's webinar. We have this every month on the first Wednesday of the month, and the session's available to any licensed life insurance or financial professional. You don't need to have a relationship with advanced underwriting consultants to be able to join our webinar. If you find it helpful, please like our video, please subscribe to our YouTube channel, and pass the word along to those that you think might benefit from hearing what it is that we talk about every month. Thank you for attending today, and thank you for considering doing that. Today we're going to return to a recurring topic, that of beneficiary designation. We're going to talk about a beneficiary designation court case that I think is interesting and provides some lessons to those of us in the life insurance and financial services industry. But before we do that, before we get into it, let's decide what we're going to talk about next month. And so, if Jennifer, if you'd open the poll, let's talk about what next month's webinar might be. You've got three choices: reconsidering QCDs, ethical issues with incapacitated clients, and advanced directives, things like powers of attorney and living wills. Let's go ahead. I see the poll is open. Go ahead and cast your vote. I'll give you about 20 seconds to cast your vote. Please go ahead. See, we have a couple of people who still haven't voted. Please go ahead and get your vote in. All right, let's go ahead and close the poll. Next month's topic will be reconsidering qualified charitable distributions. Thank you for your input. Thank you for voting, and we'll talk about that next month. So let's go ahead and talk about today the beneficiary designation case. And just in the way of background, many of you have heard me talk about beneficiary designations in the past. In my career, I've been an estate planning attorney, and I've spent hours with clients trying to make sure that their estate planning objectives are reflected in their estate planning documents, their will documents, their trust documents. And in my experience, life insurance professionals don't spend a lot of time with their clients about getting the beneficiary designation right. And I think that's a mistake. I think from my perspective, the beneficiary designation is likely to control for a lot of our clients a lot more of their liquid wealth than anything that we put in their wills or trust documents. And making sure that we get the beneficiary designation right, and we make sure that we keep it right for our existing clients is an important thing. I said the beneficiary designation controls a lot of the client's liquid wealth. For life insurance, it keeps the death benefit from being reachable by the insured's decedent's creditors. It supersedes the language of the decedent's will, and it overcomes oral statements that the insured might have made to other people about who was supposed to get the insured's money. Now, it does that all the time, except when it doesn't. And so this case is kind of an indication of the circumstances under which maybe the beneficiary designation is not reliable. So we've talked about beneficiary cases in the past, and we'll touch base on a couple of those as we go through this, but we're going to talk specifically today about Primerica versus Montoya. That's a New Mexico state court case where the named beneficiary might or might not end up getting the money. We'll have to see what the conclusion of the case is. The case serves as a partial checklist of the kinds of things that can go wrong in connection with a beneficiary designation. So let's talk about the facts. Primerica Life Insurance Company issued insurance on the life of Joseph Trujillo with a death benefit of $85,000. The policy designated Cynthia, who was Joseph's ex-wife, as the primary beneficiary and Bianca, the niece, as the contingent beneficiary. And Joseph died, and Cynthia and Bianca ended up in court disputing who was entitled to the death benefit. And as is the case in a lot of these circumstances, the insurance company, in this case it's Primerica, deposited the money with the court in what's called an interpleader action, gave a check to the court for 85 grand and told the court, okay, you figure out who's entitled to it. We know we have to pay the 85 grand, we just don't know to whom, and left it up to the court to decide. And so as part of the trial process, the niece and the ex-wife agreed to some of the facts. And here are the facts they agreed on. They agreed that Joseph had designated Cynthia prior to becoming his wife, but who later became his wife, as the primary beneficiary. And he designated Bianca as the contingent beneficiary. Before Joseph's death, Joseph and Cynthia divorced. The divorce paperwork didn't say anything about the life insurance policy. And less than a year after the divorce was finalized, Joseph died. And what was also agreed that during the marriage, the premiums were paid for with community funds. New Mexico is a community property state, and community funds were used while the parties were married to pay the premiums for this policy. Now, the parties did not agree on the following facts. Cynthia asserted that she paid the premiums from her own checking account after the divorce. And Cynthia also asserted that Joseph did not intend to revoke the beneficiary status of Cynthia after they got divorced. And, Cynthia provided some affidavits from other people saying that Joseph intended to keep Cynthia the beneficiary of the policy. Cynthia said that the person who provided the affidavit was disinterested. Bianca, on the other hand, pointed to New Mexico's law that said that an ex-spouse is automatically revoked upon divorce. The ex-spouse is revoked as beneficiary, treated as having predeceased the insured, and thus Bianca said she was entitled to the money as the contingent beneficiary. And so the case raises some interesting questions that have been litigated or legislated in the past. The first is, does the revocation upon divorce statute in New Mexico actually revoke the ex-spouse as the beneficiary? The second question is, if insurance is purchased with community funds, Does a spouse or ex-spouse have an automatic right, an automatic claim against the insurance proceeds that can't be revoked? The third question is it fair under these facts to send the death benefit to the niece? And the last question is, if Joseph affirmed his ex-spouse's beneficiary after the divorce, does that trump the revocation upon divorce statute? And so all those issues are issues that have come up in cases in the past. So let's talk about revocation on divorce. Courts have been called on to decide where parties divorced, whether leaving the ex-spouse as the beneficiary is valid or not. And in general, the courts have upheld the existing beneficiary designation unless there's a state rule that says otherwise. And about half the states, maybe a little bit more now, have rules that say that when parties divorce, the now ex-spouse is automatically revoked as the beneficiary. Automatically, or sometimes the language says is revoked. Each state's language about this is inconsistent. Some states don't have any language at all. Other states have some language, and the language varies from state to state as to exactly what effect this is. And so the court was called on, in this case, to interpret New Mexico's statute. New Mexico does have a revocation upon divorce statute, and it says, you can see the language on the slide, divorce revokes any revocable disposition or appointment of property made by a divorced individual to his former spouse. So it seems clear that the statute says a beneficiary designation is revoked. Not so fast, the court said. The judge said New Mexico's courts did not address yet whether divorce absolutely revokes a beneficiary designation or whether divorce creates a presumption of revocation that may be rebutted by other evidence. And the judge decided in this case that the New Mexico statutory language was not an absolute. It only created a presumption of revocation that could be overcome with other evidence. So the statute wasn't enough to finally decide this case. So Cynthia went on to argue with the court, or argue to the court, that this was a community asset that she couldn't be revoked. She may have pointed to a California case where a court found that term insurance paid for with community funds, whether that was community property, the death benefit was community property or separate property, depended on who paid the final premium. That was the decision in that case. The judge noted that while the parties agreed that some premiums were paid with community funds, there was some dispute over who paid the last premium. But in any event, the judge did not accept the argument that that simply paying for the policy with community funds made the death benefit a community asset, and thus made it required to be paid to Cynthia. The judge didn't accept that argument. So the next argument Cynthia raised was one of fairness. Under the circumstances, she argued she paid the premium, so she should get the death benefit. There's an Illinois case from 2014 where the Illinois court found in favor of a spouse on a similar argument, but the judge noted that it wasn't certain that Cynthia paid for the policy under her own, from her own money, and so the judge wasn't ready to say as a matter of law, as a matter of requirement, that Cynthia was entitled to the death benefit under these circumstances. Cynthia also argued that the beneficiary designation was affirmed post-divorce. She provided an affidavit by her ex-husband's business partner, under which the reportedly disinterested person said that the deceased had intended to keep his ex-wife as the beneficiary. The court said the affidavit's fine, but it wasn't sure that Mr. Crane was in fact a disinterested witness. That needed to be sorted out a little more clearly. And so it couldn't render a judgment in favor of Cynthia until Mr. Crane's status, credibility as a disinterested witness was further evaluated. And so the court was unwilling to go that far. And so since the court wasn't willing to kind of make a final determination here, and it denied both parties' motions for summary judgment. The case is proceeding along the path to trial, and attorneys are getting paid, which on one hand warms my heart, but on the other hand, really, that's not how we want to serve our clients. We don't want our clients to end up in litigation arguing over who's entitled to the money. We want that to be as clear as possible on the front end. For various reasons, because first of all, it serves our clients well, but second of all, it gives us the opportunity to work with the clients, next generations, successors. If the process of their getting the money is fair and simple, then it maximizes the chance that they'll continue to work with us. So one of the main takeaways from the case, in addition to that, is: are you working with your clients to proactively check on their beneficiary designations? That needs to happen. Circumstances change. Even if you've got a perfect beneficiary designation on the day the policy is taken out, doesn't mean that it's going to be perfect on the day that somebody passes. And so checking in regularly is a really important thing. And certainly in the Montoya case, if Mr. Trujillo and his agent had talked about the beneficiary designation, and perhaps if Mr. Trujillo had sent in a new one naming his ex-wife as the beneficiary post-divorce, or in the alternative, naming his niece as beneficiary post-divorce, that would have cleared things up and perhaps kept the parties in this case from litigating and using some of the insurance proceeds to pay lawyers when perhaps they didn't have to. So obviously, that's an opportunity for us to be proactive with our clients, to check in, make sure circumstances haven't changed, to make sure that their beneficiary designations are correct. So keep in touch with your clients, keep in touch with us. Thank you for joining us today, and I'll turn the program back over to Jennifer to wrap this up. Jennifer?
Thanks, Linus, and thanks for joining us today. And join us next month on June 5th for Reconsidering Qualified Charitable Distributions. As a reminder, if you would like to receive supporting materials, feel welcome to email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.